don't, when you amend proclamation, you don't read I amended by virtue of section 9 of the interpretation proclamation, because the power is there. The original power was there to determine a menu, from a menu of days and particular months in section 63, one or more days. There was at some stage even the suggestion that all elections must take place in a single day. Now we know from history that the same act in RP3 and the Republican Party places. In fact, that day 27 of November seems to one that comes to multiple states on a yearly basis. But on many other occasions it took place over 2 days. Now, I will deal with the provisions of the Act to make these revisions to the Lordship. But before I do so, may I just emphasize that what our legislators do not do is to refer to the facts. And what the facts were when the President issued the proclamation, the Lordship will find in his answering affidavit to the IPC at paragraph 5 on page 5 and 6 of the record, and particularly from paragraph 13.1 to continuing until paragraph 18. And those are classical elements will be the facts in which the Lordship decides in this case. And I'm not going to read it, but what does the President tell us? He says this. He said, I received information that at certain polling stations there may have been people with the card of the right to vote. I was informed that at all other polling stations, but for those which will eventually included in G34, at those polling stations, and that's supported by the those polling stations did what they had to do, even in terms of section 19.3, to continue with the voting until whenever you finish. Notionally, my lord, if a section 93.3 problem after 9 arises, it is notionally possible, particularly in this election as it is explained, that you will not have to vote in the place of registration. So anyone can vote anywhere. So notionally you could end up in the Kuahapa Hospital queue, and there were 5,000 people in the queue at 9 o'clock. And that would have taken another day or 2 to finish. Now, what would be wrong in those circumstances if the President, just as an example, then issues a proclamation for the next day at, say, 2 o'clock, so that that's also declared. And remember, my lord, there's only one person that can make a publication or a proclamation with the effect that it's a public holiday. So, if the President, if people continue to vote, say, for the 2 days in terms of section 93, there's only one person that can say, I extend the voting for that purpose, so that it's a public holiday. And that is another indication contrary to the provisions of the Act. As far as the landless people is concerned, your Lordship will find that page 6 to 9 of the record, and that is what your Lordship, Justice Mahinga referred to, where they deal with the separation. In fact, with respect, we find it strange when it's common cause that before the LPM got its application for Mr. Swartboy, each visa application in this that he was already in possession of the Lordship will find the figures in the answering affidavit of the LPM. It's a bit unclear, that document. It's too small. I beg leave to hand to your Lordship the last copy of the figures in the presidential election. But it is in any way also explained in the answering. So,
Mr. Inspector, we understand the legal provision that voter can vote at any polling station. The voter can vote anywhere, not necessarily where they are registered. And of course, we understand the problems the Electoral Commission was having. Now, why and how does the Electoral Commission assume that people should only vote at those 36 places if they are allowed to vote anywhere?
Because it was only at that 36 places where voting could not continue because they were not ballot papers. At all other polling stations, there were ballot papers and people continued to vote until they were done. So if the president, then if there was a recommendation by the ECM to extend that all polling, to extend for purposes of all polling stations, then they would have said that was not necessary. And then I declared that unlawful because Section 9 only deals where it is necessary. You damn if you do and you damn if you don't, according to the LPM.
Yeah, but the point is, the voting was extended in respect to people who were not necessarily in the queue.
No, but that the idea was that if you do that, those who couldn't vote, those who were in the queues, where they were ballot papers, finished their vote.
Yeah.
And then there were those at 36 where there were no ballot papers. And you could have, of course, asked them to stay in the queue until the ballot papers continue, but that would have been a bit rather degrading to go there without water and food in the queue until the 29th. So what the president was advised is only to extend the election period, and it was the commission that decided only at those periods. The president, with due respect, did not say, he just indicated where the polling stations are represented, but he did not determine hours or nothing. I will return to that in due course.
To clear that the president did consider also extending the voting period for the country.
Yes, he did consider, I mean, the advice, not advice, the facts which he received. Remember, that was on 28th. The date of the communication of the president is given by the ECM at 9 o'clock or 11 o'clock that evening. So the decision-making process was around about just before that, and then it still had to be published. Because by then, and in fact, what many people of the polling stations actually did for them, and to get them back what would have been an impossible task, 3,600 polling stations, and the president said he was advised that it is not necessary at those times. Why was it not necessary? Because at those polling stations, people who wanted to vote there finished and got the job done. And we also know that counting at those polling stations started at some places were finished on the 27th already. And in fact, the LPM annexes to their replying affidavit accusing the president of not telling the truth, but that you also will find that record page 1276, and they attach and it's a BS 9 to least none of these, which they mentioned at the time affidavit, indicate are those at which election that polling took place on 29 and 30, because they were done at those. The counting took place on the 27th, as it is stated in the whole version is attached to the IPC's counting papers, the press release that was made by the DCS. Those are the common cause facts, and there they explain in detail why it was only necessary at the 36, because those were the problems, and that is where it was necessary for the extension. Now, having said that, my lords, can I then turn with your lordship's leave to the bundle of the statutory bundle, and your lordship will see that in the first few pages, because it becomes important when one determines the owner's issue, that is from the first pages until page 4 and until page 8 are from the old 1992 Act, which played a part, at least in the full legislation and also the RPT. So that must be taken into consideration. But turning to the Electoral Act, it will also allow me to quickly run what we submit are important factors. So I will start at the definition section of election, and I'm not going to read everything, and then we've got the definition of general election. I have marked mine also in the authority bundle, and I hope it's shown in your lordships as well, in the authority bundle. But continuing with the Act, I just identified the definition of polling day and polling station, and then your lordship will also find the definition of subsection 1.2, that is after the definition of voting. Now this is a new provision which was not in the previous Act which served before this court. And that is section, the definition says in section 1, subsection 2, it starts after the definition of voting scheme. And it says a person, which was with respect to this court, interprets or applying this Act must do so in a manner that gives effect to the rights, freedoms and responsibilities contained in the Namibia Constitution, and take into account the Bill of Fundamental Voters' Rights and Duties and any other appropriate law, which would include not only the Constitution but Section 9. So if you interpret Section 9 in the context of what we refer to in our political argument, I'm not sure whether in England, when they first made the interpretation of the Laws Act in 1899, which of course spilled over to the colonies then, the lordship will find this particular provision in article in Australia, with very strong on this, New Zealand, and each and every single Commonwealth country from 1899, and those were over time developed into constitutional provisions because of the constitutional, as they say, the unfortunate problem that you were not re-exercised. So the ultimate question is, if we continue, we are looking for a contrary indication, and you will interpret Section 9 of this Act in accordance with the provisions to give effect to voting rights, not to take it away. Of course, it's limited by its context and its actual wording, but that is the start, purpose, not the structure, as our young friends say. you've made this decision, it's final. You find that within the legislature, it's final. So then, once that finality, which is a principle of conclusive picture, is indicated, then it will be a contrary indication. So then we cannot apply Section 9. The best example of a contrary indication in this Act, you will also find at Section 78. That's possibly the best contrary indication where the President cannot exercise the right under Section 9. 76. But no, I just make it a year. 76 talks about lack of nomination of death. And it says if, and we also say if we, the duly nominated candidate for the election of the President dies or becomes incapacitated, that's Section 76. B. Then there is only one option. If it is before the poll for the election has commenced, or while the poll for the election is taking place, the Commission must immediately terminate the election and all proceedings may take place. So if the President in no circumstances issue an extension or amend the original proclamation, that would clearly be contrary to the contrary indication in the Act, or where the Act says something was final. Now, if you also then go to Section 64, 63, and all these sections will indicate to you also that the President may have done what he did. Now, 63 speaks about the general election must take place and then aim for an election of President on a date not earlier than 5 months and not later than 3 months prior to the date on which the term of office of the President expires. And we know the President says, and that's not a dispute, that his term will expire on 21 March. So, the 5 months back is 21 October of last year, and the 3 months backwards is 21 December of last year. Within this menu of 3 months, any election could take place. And so it is not, of course you must do it before, you must say before it comes, nothing needed. You can't do it afterwards if the day is gone. So that the word before means nothing, it's a neutral word in this context. So it kicks off with 63. Then you move with respect to 64. And it then says if a general election is to take place in accordance with Section 63, in other words, within those period of 5 and 3 months, amongst others, it must find proclamations in the Gazette made known of the word before, it's not in there. That they get from Section 93, which I will turn to in a moment. And then it says, in case of such election, should one for the President and you speak 2 and 3, a date determined by the President upon recommendation by the Commission, upon which the submission of nomination of candidate must take place, and the place at which it must take place. We also can insert there at page 327, 16 October last year was that day, 3 to 7 of the record. Then it says, in 2, despite anything contrary to the Act, which then deals with the outside Namibia stuff and so forth, and then it says, before the polling day determined, day not less than 40 days and not more than 45 days after the nomination day. Now, the lordships count, and that is also common cause from 16 October, the period 26 November to 30 November fell within that period. And so the 27th of November was within the menu to take for the elections to take place. And you could extend, so to speak, without not complying with the provision taking from that menu until the 30th. And that is exactly what the President did. But more importantly, also importantly, it says in 6 of 64, any day determined under 1B for an election of President is a public holiday. It doesn't say must still be declared a public holiday, it says it will be. So when the President made the extension and the 27th, those days were public holidays. And it is only the President that can do that. So if you are in the queue, for instance, 1993, 3 queues, so to speak, and you run over for 2 days, which is permissible, then the President can simply say, I also publish those days to be part of the election. And that will then automatically be public holiday. No contrary intent, nothing. So if one can continue then, where
of the sense in which that provision of public holiday can be significant. Say somebody was dismissed for not having gone to work on that day. They can say, no, you couldn't have dismissed it because they are deemed not working at work.
yes, that's okay. Well, we're coming to the this deeming thing, which I haven't mentioned. It's almost like a silent recession coming. But we come to the cumulative. Now, 93, my lord, is simply a statutory provision of when, if there is a day or days published by the President, those will be the hours. It's not for anyone to change it, reiterate it, or whatever the case may be. I will show you lordships, and they are quite correct if they refer to sub 2. It says the Commission, not the President, may alter by notice published in the Gazette at any time before the commencement of the poll. The polling hours are included in subsection 1A in relation. Now that was done, my lord, never. The polling hours never ever were changed. They always remain as they are in terms of section 93. The Commission never changed the polling hours. What they did do is what they explained in respect of those mobile stations. Now that they did, and there's no complaint about that. But once those hours were made known, those were the hours which were applicable of 29 and 30. The President didn't change anything, let alone I hear again that he changed the polling station. He didn't. So, but importantly, also in the provisions of the Act, I must take the lordships back to section 64. 64.4, which is also a powerful indicator that nothing indicates the contrary. It says in step 4, an election is deemed to commence on the day stipulated in the proclamation referred to in subsection 1, which is published in the Gazette. Now, importantly, step 4 only speaks about the election. It doesn't say when the election will end. If it says it will also end on the day originally published by the Prime that he might not use section 9, but in fact the contrary appears that he may use it, read with 1, 2 of the definition. Then, my lords, 94 is a very, very powerful indicator what may happen. It is not a contrary indication as in the section 9. Now, if you also are with me, it says 94 the presiding officer and other officers at the polling station specified to each officer must. You then go to sub 4. Sorry, sub 5, and it says what they must do, and then sub 5 of 94 is crucial. It says, despite anything to the contrary in this act or any other law, despite anything. And it says, the presiding officer who is of the opinion that there exists at the polling station a situation which threatens and ABC lordship can read, but F is crucial. The taking of the poll there act to the extent that the objects of the act cannot be achieved. If he forms that opinion, the act makes very plain. He or she must forthwith discontinue the taking of the poll and close down the polling station, whereupon poll must be taken at the time, in the manner, in respect of the voters, as may be directed by the returning officer, concerned after consultation with the chief electoral officer. 6. The powers conferred by this section is but only one prohibition, and that we may not exercise it so to prevent any voter who is entitled to vote. Now, my lord, the issue was not in this case that any electoral officer may not have used this. Assume this, but this is not what we say because it's not an issue on the paper, but what this is a powerful indication that in those circumstances, the president may, if it is recommended to him, if the electoral officer says, we're going to open on, we close down, we're going to open on the 30th, and the ECN said to the president, we recommend that you also publish the 30th as a day on which this election now and the extended forms of that. Then there would have been no way that the president would act unlawfully, even if there was a breach in time. Even if that they so fixated on contract law that you cannot extend something which came to an end. Why not? If the power is there and you extend it, then you extend it. Even if it's retroactive or retrospective, because they're not complaining about the retrospectivity for good reason. No rights were taken away retrospectively. Rights were given retroactively by the president. So again, this is a powerful indication that section 9 does not indicate anything to the contrary. Then, my lord, can I just not deal with 115 for a moment, but we then come to section 204. Yes, it's in there, you also have heard that number today for very good reason, but let me read it to you. Now, 204 is a new section. It has not been in any section of any act before. And one can understand why the legislation did that. Because of the rule of non-hearing. Because as soon as the writing is on the law, and every agent in the field sends the results on the wall through, you quickly do your calculation. I failed again. Let's just start complaining and look for reasons to challenge. And let's feed the nation with false facts. And that is what always happens. Your Lordship will read every judgment, and your Lordship, Mr. come with facts of the rumor number, and again we have that. And it is time now, on these facts, it is also permissible to say, now you pay the cost. Stop it. If you have valid complaints, then you come to court. If you read the entire act and you can comply with the entire act and you've got a valid complaint, then I will, and the court shall, I know the court will, then accept, and if it is necessary, set aside. And then you get facts, not too difficult statements and labels that we read about in the Charlie affidavit. Now, paragraph section 204 says, an occurrence book is to be kept at every legislation for a polling station and information center in which then deals with three things, in which all complaints eventually each person is dissatisfied and incidents are recorded and signed by any person present as a witness. But any event or complaint, now importantly, my lord, it does not now speak about an incident, because an incident seems to be a material of the thing. That is not recorded and signed for an occurrence which is deemed not to have occurred. But even if we got it in there, and the burden of proof lays with the person engaging the occurrence of the incident or complaint. So now incident is put back. So, and the complaint. So, but the point is this, as threshold, because of all the rumors and the like, it is the legislature said, from now on, having read, I suppose, all the previous judgments, from now on, we're going to put the threshold. Facts will not be disputed if it is not in the current, and you read it and you comply with it. Now, there is no dispute that the current is kept, and there is also no dispute that not a single one of these complaints has to vote on what they call days that shouldn't be voting days, is in the current. What the LPN does is to say, well, I've got a clever idea. This occurrence book does not deal with ultra-virus, but with respect, my lord, section 64 is in our. So, if you voted on the 29th and the 30th that there was an ultra-virus, then you had to report on the 29th and 30th when you were there. So, what's going on? I see people voting here on the 29th, you must report it. Why did they not report it? Because they asked for it. But when, unless, again they lost after that, then suddenly they say, I asked for it, but where do you get the power from? By the way, that's what they do. And I will refer, and your Lordship, Mr. Justice, Nampa said, did not indicate anything but asked the question, is this relevant what they asked? I respectfully submit it is. Because if you look at section 172, which brings us to this one as well, then is it 172? Now, the presidential election challenges. In any election of the president, any challenge relating to the third outcome of the election. Now, you will also dealt with that in detail in the Itula case. This kind of complaint that the Itula case says will also include any other like what we have here. So 172 takes you to 204, because what they now say is this 172, our complaint, ultra-virus complaint, is not really a 115, but it's wrong. The Itula case already rejected that, because you must go through 172 to get to the score. Now let me say this one, with respect. If you look at the provisions of the Act, in Part 5, every non-compliant conceived receivable by anyone concerned in worldly and full-craft either state, either by commission or by commission. If a polling officer stops someone to vote, he would be acting ultra-vires. If he stops 500 people to vote, he will be acting ultra-vires. If he allows 9,000 to vote on 29 and 30, he will be acting ultra-vires, but it must go into the government. And this is so important, my lords. Recently we referred to the judgment which was framed, and I hope I'll give you also the right credit now, Mr. Justice Landless. You wrote the judgment on the deeming provision in the case about the Provisions of Public Service Act. And there your lordship set out actually correctly. We submit in the circumstances of this case, where there is no complaint that no one could get to the current book at any of the time, that they couldn't insert it. That is the end of the inquiry. And nothing can be disputed. And we submit indeed, my lord, that it is an irrebuttable presumption which is correct. If your lordship, one cannot always give everything that you research. Any evidence book dealing with irrebuttable presumptions, tell your lordship, your father, Hoffman, Bedford, or doesn't matter. Which says when it's irrebuttable, it normally says unless otherwise proved. But this one is an indication that it is irrebuttable. And no argument is made about that. It just said, because it's ultra-violence, it doesn't count. Of course, you should have been there calculating, saying you can't vote with it. But of course, you want your horses, you see, perhaps I add another seat. But, so I don't want to object now, because I've also asked for it yesterday. And then, if it's not your way, then your lordship will see, for instance, in the document which I've handed up, in the National Assembly election, despite the fact that the IPC and we have all these loose allegations that they were swappled strongholds and so forth. If you also look at the last paragraph from the election, the IPC, as a result of that, won an extra seat. If they win in the High Court, they lose an extra seat. That's the fact of the fight to face. So we do not know what to put, but it's still important to determine GT34's validity in the context of that, because there, the materiality and there's a different figures involved.
I have a concern about something you said. If the kind of illegality they rely on is a good one, I don't see how it fits into the 205 category. For example,
You said it's a good one.
if it's a good one, yes. And that was the context in which I was saying. Look, the fact that they requested is irrelevant. If it's unlawful, it's unlawful. Say, for example, the Prime Minister declared the date of the election. I mean, you can't tell me you should have taken that to 204. Illegality is an illegality.
Is that exactly? We know what the law is normally when we deal with those illegalities, and we have to lecture about through it. The question really is, this is not a Parliament's part, that even if, in the laws of example, say that Prime Minister declared those days instead of the President, yes, it may be good strictly speaking to the higher. Isn't that the 204 education school? That if you don't complain about that, I know it sounds strange to a lawyer, the deeming provision is a funny thing, but that's what Parliament wants. And if that is the effect and you want to challenge it, then you challenge it.
No, I just want to add what the Deputy Chief Justice put to you. If you look at this provision in the context of the Act, it seems to be much more related to what is happening in polling stations with registration points. To proclaim something in the Gazette is something quite different. This whole idea, it's to do with the proof of fact, isn't it? And there's no proof of fact when it comes to something that the President was authorized by the Act to do something wrong.
No, I agree with you with 100%. And we do not suggest, of course you can put in the current book, but that doesn't make it legal or not. But what the Act is aiming at is not the government that is at the voting on day 29. And we say, if you have an objection, you have to report the voting. Because every other provision falls in 5 of the Act. If you transgress it, then you have to provide. I cannot think of any provision of the Act which will then find its way into the current book, which you cannot close or explain by the example of our principle of legality.
What about Section 1 and 2? Section 1 and 2.
Yes or no?
Doesn't that negate your
No. You will be effective. You will right to vote. Trying to stop it. I understand, but perhaps I should read to you. I have, and I'm not going to make a copy. I've got a book, Interpretation of Statute of Depa P. Saraki, which is the King of Queen's Council of India. And of course, the Act of 1889 also found its way into India from England. And he discusses it page 289 as an example what the court will uphold and how ridiculous it may sound to a lawyer. He says a fiction is a legal assumption that a thing is true, which is either not true or which is probably as false as true. For example, Rule 46 of the Oxford Union Society provides any member introducing a dog into the society's premises shall be liable to a fine of £1. Any animal leaving a blind person shall be deemed to be a pet. Now, that is a real life example. So what the legislature does is to draw the line in the sand. If we can start distinguishing actual illegal voting or actual illegal stopping with reference to ultra-virus, then 204 becomes enough. Because I will consider what I will say if I can point to any section in chapter 5, part 5, where this is transgressed, which we cannot cover as ultra-virus. And we know not to do something which you should do can also be ultra-virus.
Tell you what.
Yes, thank you. So, what we submitting is that 204, unless you attack it, that is the result. That there was no complaint in this. That's the end of the inquiry. Now, he said it is legal. Now, my Lord, I must finish, but may I say this? So the road goes like this for a bad challenge. It goes through 172, and then you come to 115. I don't have time, my Lord, to deal with this bundle of authorities which I've handed up on illness. I just say this in short. Every case that dealt with illness in this court is in here. I have, before I made the copies and the numbering, highlighted the portion
They're not meant for eyes.
No, these your rules are just highlighting. It's not but very got the same. What I want to just suggest to you is what makes it the test here. And what the Putter versus Tai case, which is the first case in the bundle. Now that case was pivotal in the judgment of the full court of Mr. Justice Nampa Maritz and Fillemon in the case of party case eventuated in the lead count. And in that case, the full bench made the reference to the old cases, the English cases, also the one of Lord Delhi and so forth. They are all in part. There was nothing new. And what the Supreme Court did, the full bench did, was to, at page 11 of that bundle, that portion in the middle, the bundle is marked right at the top. And Putter versus Tai, it says, passing to the owners, this is Justice Landless speaking. Remember my lords, this is a case of application for the which was eventually discussed. It seems to be clear that once it has been shown by the petitioner that a non-compliance with the provisions of Chapter 3. Now you also foresee that in those provisions at the time there was also a distinction made of the provisions of the Act and the principles of the Act, as it is still today. It says the onus lies on the respondent to prove that both conditions mentioned that they call the theories of the sections have been satisfied. But this is what was quoted and eventually came into the full bench and into RDP, and of course in the Tula case it was corrected a bit. Although the Tula case did on deal with owners. So, but this portion, I just want to point out to you, Lordship, is misleading if you only quote that portion, or can mislead the reader, not intentionally mislead. Because Mr. Justice Tindall was dealing with the issue of the Act as it was then, and for that I must refer your Lordships to page 8 of that one. And you will see I've highlighted the first portion. And I start at the second sentence. And he's now discussing the provision which is quoted from the previous page. The old section 91, no election shall be set aside by reason of any mistake and non-compliance with the provision of this chapter, which it appears to the court that the election was conducted in accordance with the principle laid out. Non-provision or the principle. But then he discusses at page 8, he says it is not reasonable to construe section 91 as relating only to such relatively unimportant non-compliance with the provisions of the chapter as do not immediately increase the fundamental principles of the election by ballot, and in that case was on secrecy. That means when the section says if it appears to the court that the election was conducted in accordance with the principles laid down in the chapter, it must mean something different from if there has been non-compliance with any provision involving a matter of principle.
You can refer us to the relevant pages and
So,
give me enough for ourselves.
yes, thank you, my lord. So, I would say, may I just finish? I know that I know.
We're out of time, I'm afraid. But we can address that on the cost.
Yes, my lord. I respectfully submit. Can I just end up then this reinterpretation of statutes, which I won't read, but that is in relation to when a proclamation comes into force. That is how section 12(2).
reading the time reading. If we do read enough. If it's good.
Okay, so what is the date of the document is the date which you will read from the previous time. So in any event, as the first one, I respectfully submit that this application of both these parties should be the dismissal to carry the cost in our case one instructing, two instructing. It is not, it may be different if we didn't have a clue. But if you have a clue and the court has spoken on the case, and in that paragraph 5 it says that even if there was substantial non-compliance with anything, then still it's remedied. And they should have, they mean, that this is completely unnecessary. There will not be a difference. The results will be known beforehand, and again, will continue. And for those reasons, and also the remarks, mostly as far as the President is concerned, Mr. Sparkman, why does he say, not only in his notice of motion, but in his affidavit, that the President acted while either? I respectfully think that the application should be discussed for both parties.
There was at the outset, wish to submit that we will not persist in the point relating to the authority of the LP. Mr. Schwartz, who was a candidate in the presidential election, is before court. And he is stating to be here, so that obviates the need to decide the question of authority of the LPM, because it does not take us any further. And that issue of authority of LPM is also raised in the court below. It is a live issue, and it is real consequences for the decision of the court below. So we will pursue that matter in the electoral challenge before the electoral court and not here, because it is not dispositive of this specific application appointed. Now, as far as the application for joinder is concerned, we only make one point. We have taken note of the authorities that are referred to by LPM. Your Lordships, the only point we will make is Rule 7, Article 17 of the rules of this court. Rule 7, Article 17 of the rules of this court provides for how a party to the proceeding can become an applicant in those proceedings. And that will clearly provide for the timelines within which that has to happen. So, the rule provides that in such event, the applicant can make an order application, and that affidavit must be filed together with the answering affidavit. Now, I hear that the submissions on behalf of the LPF in this regard, if the court is to accede to those submissions, we say that the control that the court is under Rule 17, Rule 17 or 17 of the rules, insofar as the timelines within which the papers have to be filed have to follow, and then it becomes a normal application for Jordan with its own time, and also the provisions of the rules related to the filing of the pleadings, then become.
What is the bottom line? Is it the ECM's case, LPM should not be part of it? In this case, forget about everything that they placed before. Is that the bottom line of the ECM? So that we can really decide what is our important issues.
I just want to add on to what the ECJ has put in. I found it quite strange that the ECM is engaged in this type of point taking. And there's an impartial, independent body. I would have thought the duty of the ECM is to put the facts before the court, let the different protagonists and not for this kind of point taking from the ECM.
It is not.
Having actually seen myself previously on more than one occasion, that's certainly how I felt that it should be done. And also not engage in name calling and that sort of thing, in keeping with the type of independence and impartiality which is supposed to come with the ECM. And accountability.
We just act as a public body and what ECM's duties to assist the court.
You said it's right to assist the court,
And not to really engage in activistic jurisdiction. It is more point like the one that we are now abandoning.
I hear all of that. Only thing that I'm saying, take as account of Rule 7, Sub 117, Sub 17 of the Rules of Court. So if the court is content, or if this rule does not raise any concern to the court in relation to how
Every rule is concerned with the court. You want to know your bottom line. Is it your bottom line? Chuck them out, forget about everything that they have said, and decide the case on the basis that they have not participated. Is that ECM's bottom line?
if there is import of the rule.
Sorry?
If there is import of the rule. So, but if there is not import of the rule, then we can obviously the court must have made some responsibility.
Right.
So that is the only way that I can make that. The next aspect I will deal with the budget. Actually, this is the main submissions of the ECM. There are two particular aspects that I want to deal with. The first one relates to the processes and the returns at polling stations, which have not been challenged. The principal submission there will be that at least a substantial portion of those returns have to be challenged. For one, to be able to upset the announcement of the results. And the second part of my submissions will relate to what we referred to as the principle of subsidiarity in the context of the application of sections 115 and 204 of the Act. May I just move forward to the question of the return? The lawsuits, we have referred the court to the powers of the returning officers and the deciding officers as they deal with as they conduct the elections. Section 110, subsection 5 of the Electoral Court. The head of section 105. Subsection 5 of the it reads, the deciding officer must, in the presence of the person, refer to subsection 1 endorse whether rejected on any ballot paper rejected in terms of subsection 3. And then subsection 8 of that section. When counting of the votes is completed at the deciding officer must cause the counting agent present to record their presence in the prescribed form and manner as proof of presence of the county, announce in the prescribed manner the return of the count, inform the returning officer thereof, and post the copy of the result at the polling station to observe. But in the case of the local polling station, the results of all the polling stations for that local polling station must be posted at the closing of the poll where the votes are counted. And then section 109.
Yes, I understand their case. They say the ECM gives a directive late 2027, which directive starts a process which leads to a proclamation passed by the president to extend the voting, and that's the unlawfulness. Where do these things of the returning officers and what can they are challenging that action of extending the election? Now, what difference would it make if they decided returning officers? Is it that which led to the extension?
No.
It's the unlawfulness.
I get that, because we're not saying that she has cited the returning officer. What we are going to submit in full circumstances to see is that under section 115, the motion if there is no proper challenge to the returns such that it shows that the elections were not conducted in accordance with the principles, the court cannot accept the elections. So I'm getting to that proposition. I will deal with many of the subject matter. So what I'm submitting is that stations by presiding officers. Those decisions lead to the publication of what is called the 37 form that is pasted on the wall. And under section 204, everyone is provided with the facility to record any, they call it mistake or non-compliance because of the word within section 135. But section 204 is amended and submitted. Deals with the reporting of the occurrences, events, perhaps irregularities, or even illegalities on at each of the polling stations. So once you have section 204 require the report of those irregularities, illegalities, fraud, whatever, at a polling station. It must be that it creates an opportunity for you to challenge a specific criteria.
The directive was not issued in a polling station. It was done at the Electoral Commission headquarters. I said the directive was not issued in the polling station. It was done at the Electoral Commission headquarters and the proclamation signed at the State House.
Yes, also, but the repair was made at the polling station.
So, I'm sorry. I'm unable to follow what my argument is. What is a criminal crime?
What I'm
You
submitting
can
is,
summarize your submission perhaps to make me understand it better.
yes, each and every return is made based on the powers that are conferred on presiding officers, and they make administrative decisions, and those returns cannot be challenged instead. And those returns are the ones that inform the final results that are announced by the chairperson. And the Act provides for an opportunity for the process by which we can prove each and every one of those returns one, and that is provided in section 204. So, without those returns being challenged, they exist as a matter of fact. They have a record of the votes that are counted at each and every polling station. And those are the ones that are collated for purposes of announcing the result. So not about the extent.
That's the 4,699 of them.
Yes, sir.
You should have challenged each one of them.
Not each one. Sufficient number of section 120. Not each one. Because the threshold is set in section 150. Now, let's look at section 150, which is, I think, I can move quickly to section 150. In the submission of paper amendment of the President, no election may be set aside by any competent court by reason of any mistake or non-compliance with this part. We know from the rules of Article 85 that is the prohibition. No election may be set aside by any competent court by reason of any mistake or non-compliance. So, the first part of that section assumes can establish mistake or non-compliance. The first part of it says any, so it does not qualify the mistake or non-compliance. It does not qualify at that stage. But it assumes that there is a mistake or non-compliance and therefore prohibit the court from setting aside an election. And it says, it provides a condition. If it appears to the court that the election in question was conducted in accordance with the principles laid down in Part 5. Now, as the President submitted, it should then be clear that non-compliance with Part 5 is not equal, or may well not be equal, to not conducting the elections in accordance with the principles in Part 5. It's not the same thing. So if there is a non-compliance of any mistake in Part 5, that does not, by that very fact alone, equate to the breach of the principles, because even in those circumstances, it may well appear to the court that the election was conducted in accordance with the principles. And then there's a conjunctive and, that's the of the applicant's argument. And the mistake of non-compliance did not affect the result. So if it is conducted in accordance with the principles and the mistake of non-compliance did not affect the result, the court cannot set aside the elections. It is prohibited from doing so. Only instance where the court can consider setting aside the election, and this is also where Pitula takes us in judgment of this court. Only instance where the court can consider setting aside the election is when the election was not conducted in accordance with the principles and if the mistake of non-compliance affected the result, then there is that discretion to set aside the election. Now, the Lordship, it is important not to equate or not to elaborate the principle of legality outside or the scope of the reach of this section, because the section itself subsumes legalities. It subsumes it by the assumption in the unqualified statement in the first part of the section without a qualification. Without a qualification. The only qualification there is to a mistake or non-compliance when the court considers that they affected the results. So, the principle of legality cannot sit outside the reach of section 150 because the section itself says so. Because the mistake of non-compliance, by its very definition, must be a serious issue. Because once you say you don't comply with Part 5, you must be saying you've failed or you've breached one or other of the exceptions. Yet, even in those circumstances, the court is still to consider whether the election was otherwise conducted in accordance with the principles in Part 5. So, Your Lordship, I must disagree with my electorate for Albania to illustrate the legality question outside the scope of reach of Section 115. It is subsumed in 115. This is the context within which the principle of subsidiarity arises in our respectful submission.
The 14 governors, Namibia sees someone and declare an election that comes within 115.
Pardon me, Your Lordship?
If the governors, 14, I think at the moment they are 14, see somewhere they decide there must be an election, or they extended the election, that falls within 115.
If they declare the election invalid, or
They extended the election.
if they extended the election,
We governors who were disappointed, most of our people did not vote, we are extending the election. It falls within 115.
Your Lordship, would Your Lordship still be able to find in those circumstances that it was conducted in accordance with the principles under 115?
I'm asking the question.
That's a virus issue, isn't it?
Yes. Yes, Your Lordship.
So that's what we do the salvation.
Yes.
That's so far. That's what for us here.
Yes, Your Lordship. If the governor somewhere decides to extend, I mean, Your Lordship is testing my proposition. If the governor somewhere sits and decides to extend an election, Your Lordship will immediately find a mistake or non-compliance.
That's 115.
Yes, immediately. Your Lordship will say Section 64 confers the power of the President to set the date of election, and not on a governor. Section 64 is in Part 5.
But remember, Mr. 115 says, unless it affects the outcome.
They are conjunctive.
I think I got the answer. You said it's fine. It will go to 115. Meaning, if the result will not be affected, the declaration by the governors will stand.
No.
Oh, I see.
That is not what I
Oh,
said.
okay.
I understand 115 is a conjunctive requirement. The court is prohibited from setting aside the election if it was conducted in accordance with the principles of Part 5. Okay. But if it was
For
not,
me, that is not a mistake or a non-compliance. It's a vandalism of the Constitution. That's vandalism. You can't do that. So don't even try to take it to that territory. I'm surprised you persist that it's the sort of thing that goes to 115. But I think I got my answer.